Hey there, Mark Hoffman, Lakes Area Home Investments. Just want to put a quick video together. This is actually I'm gonna go to a different video that I recorded previously that talks about the due on sale clause. So when we take over debt, a lot of times sellers will be concerned about, hey, my mortgage does not allow contract for deed, my mortgage does not allow transfer of ownership, and so this video specifically talks about how we use existing debt to buy up properties. And a lot of times people say, well, is that allowed? Is there a law against that? There's no law against this. There is a clause that I talk about here in the next video within your mortgage. It's called the acceleration clause. And so we'll kind of get into that right now. So again, Lakes Area Home Investments, we buy and sell residential property across central Minnesota and Colorado, California, most of the western states. We focus a lot of our attention on Minnesota and Colorado. Thanks so much. Enjoy the video. So my bank won't allow. Okay, so what you're referring to is there's a clause in most mortgages, most residential mortgages, unless it's a VA loan, FHA loan, or a USDA loan, or an older loan that has a clause called the due on sale clause. It's also called the acceleration clause. Basically what it says is if you transfer the ownership of the home, then we may call the loan due. We may call the loan due as a recourse. So that's what they're saying in their mortgage. You sign the mortgage, and so you're agreeing to them, and the language is specific. It says may. They may call the loan due. They won't necessarily always call the loan due, but they may. It doesn't say that they guarantee that they will call the loan due. It says they may. Okay, so let's break this down. First of all, banks are in the business of collecting payments. The bank wants to receive payments from you. They want to continue to receive payments from you. That's how banks make money. Banks do not make money when they have to foreclose. It's very expensive for the bank. It's risky for the bank. They don't like that. They don't like that at all. They would just prefer, they've already calculated the profit on just collecting 30 years worth of payments for you. That's what they're in the business of doing, is lending money and receiving payments. So they lend money, they receive payments. That's their business. That's how they make money. So that's what their primary goal is, to just receive payments. So so this is my experience talking. I bought 248 houses, and in this way, in this fashion, I've bought probably 148 doing this, using this approach. Most of them here in the state of Minnesota. Okay, so the first point here is the bank wants to get your payments. That's all they care about. So as long as payments are being made, typically it does not bring a red flag, cause any issues. This clause that's in most mortgages was actually written in approximately 1978, 1980, when interest rates were going sky high. So interest rates went up to actually 22%. Most mortgage interest rates kind of hit the ceiling at about 18%. So people were like, hey, I've got this mortgage at 6% or 8%, and I want to sell my house, but people can't afford the new mortgage rates. So they can't go and get a new mortgage and buy this house because they can't afford it. So people were selling their houses, like I'm proposing, selling their houses, capturing that lower interest rate. And the banks kind of caught on to that. They're like, hey, we're losing money, so we're going to include this clause in here. And so it was very popular back in the early 80s to transfer properties by, transferring with the existing financing, assuming the loan, that type of thing. Well, the bank started putting this clause in, and there are some, ways around it. There are some allowable transactions that the banks allow you to transfer without having this due on sale clause triggered. And it's the third one that we're going to really focus on, but you can transfer it to a spouse. You can include your spouse, for instance, if you were, let's say, if you got married and you wanted to have your spouse on title for asset protection purposes or something like that. So you can bring your spouse in. That is not, that does not trigger the due on sale clause. And you know, the reason I wrote that due on sale clause is you can go ahead, Google that online and do some research on due on sale. Okay, so the other thing is, another allowable transaction is you can transfer to an heir in the case of death. So if someone dies, the main borrower dies, the heirs of the property can inherit that property, and it's not, the due on sale clause is not triggered. Third, and this is the one we're going to focus in on, in 1982, President Reagan signed into federal law called the Garn-St. Germain Act, 1982. So you can transfer the property to a trust, as long as it's an inter vivos trust. You can transfer the property to a trust, and that does not trigger the due on sale. And so that's typically what we do in this scenario. Now, why are we proposing all of this? It's because you owe too much. Like if you didn't owe as much, then we would not have to you know, kind of go down this route. I'd just give you a cash offer, and you could say yes or no. It's too low, or it's too high, or it's perfect, or whatever. But this is how we can buy the property, leveraging the existing financing. Okay, so we're going to key in on the Garn-St. Germain Act of 1982. Basically, what that says is you have the ability to transfer property to a trust, and it does not trigger the due on sale clause. And so that's the sort of the method that we use when we buy houses subject to the existing financing. I have a couple of illustrations that will kind of like walk you through this a little bit more. Okay, so let me see if I can. Okay, so this is an example, sort of like at a high level transfer of a car. If you want to sell a car, right, you know, the family owns the car. If you look down here, ownership of the car is evidenced by title. So who owns the car? It's the name that's on the title of the car. So that's who owns the car. And the money for payment of that car is called consideration. So that's how you transfer a car. And it's the same with a house. If you want to transfer the house, ownership is evidenced by title. So who owns the home? It's the name that's listed on title. The transfer document, how you transfer, that's called a deed. And so who owns the home? It's whoever's name is on the title. So the money for payment on the house is called consideration. Same thing. Now with the mortgage, this is how this is at a high level. We transfer it to a trust first, and then we transfer the trust to our company. So ownership is evidenced by title. Who owns the home? Who's on title? Well, trust then owns the house. So it's no longer, I can't remember if you guys are married or not, but it's no longer, you know, let's just say, you know, Megan and Jason, or whomever your spouse is. It's no longer those two that own the house. Now it's transferred into a trust. So now we call it, you know, we call the trust anything we want, you know, the Johnson Family Trust or whatever. So that now who owns the house? Well, it's owned by the trust. The trust owns the house. And then we transfer, or the beneficiary. So who owns the trust then? Who controls the trust? Well, it's whoever the beneficiary of the trust is. So we name our company as a beneficiary. So the house goes from your name, goes to a trust. Now the trust owns the house, stays in the trust. And it's not for your benefit, it's for really the benefit of the transaction. And the ownership of the trust is we own the trust. So that's how we do that. So yeah, I guess that concludes that. So okay, next questions. Good question.